The Allan inquiry into allegations about foreign-funded activists interfering in Alberta energy projects was in the news last week. And to talk about that, we've got Martin Olszynski, who's a law professor from the University of Calgary, to talk to us. Welcome to the interview, Martin.
Morning.
Now, look, this is a really complex issue. So why don't we just start with the terms of reference that have changed a couple of times, and they seem to refute Premier Kenney's a couple of talking points of his.
Well, yeah, so what's happened actually is the terms of reference themselves are set by cabinet. They're what we call an order in council, and they would have been set by cabinet. And so they were tweaked, we know, back in the summer. What's happened most recently here in the fall is that the commissioner has issued what he called his ruling on the his interpretation of his terms of reference. And what we see there essentially is further changes, some of which are supported by the amendments last summer, but then some of which aren't. And so, you mentioned the Premier's talking points. I mean, so at a high level, the Premier likes to say that there are these foreign-funded special interests that have engaged in a campaign of lies and defamation against, Alberta's responsible and economic and efficient oil and gas development. And Commissioner, in his interpretation, has basically said, I'm not going to test the 2 out of 3 of those claims. Okay, so he has made it clear that he is not going to be testing the veracity of the claims made by these groups, not determining whether or not they engaged in false and misleading information, and that is supported by the changes to the terms of reference back in the summer. But then the other really interesting thing he's done is he's essentially said, I am not going to consider whether or not Alberta's oil and gas development has been economic, efficient, and responsible. He says that wouldn't be, he essentially creates a straw man for why he won't do that, but essentially says, instead, I'm just going to see whether they opposed some level of oil and gas development.
Well, that seems to be a narrowing, a significant narrowing of the terms of reference, and almost a neutering of the inquiry, because what in the world is he inquiring into then?
Right. I mean, what's left simply is that there are groups that opposed some level of development and who happen to receive some level of foreign or international funding, which we know, of course, with some parts of the Premier's base, so it is a slander in and of itself.
And I should put on the record here, I did the first debunking of Vivian Krause's research into this topic back in May of 2019. And I interviewed on the record 15 Canadian charities, and they were all very clear about where they got the money and what they did with it. I mean, it's not like they're hiding. It's not as if it's in secret, and all of that data is available, publicly. So it is very curious. But you make the point that an inquiry like this has never been seen before in Canadian legal history.
Right. And this is based on, I mean, it's somewhat anecdotal. Maybe it's based in part on my own understanding of the area. And I teach administrative law here at the law school, and also in my conversation with colleagues. But, let's remember that this inquiry began over a year ago. At that time, there was essentially these 2 phases. Early on in the fall of last year, various groups sought clarification from the commissioner about what this all meant and how it was going to roll out. What were the rules of procedure, which is essentially really the first step, the rules of engagement, right? What kind of procedural protections are you going to have? And the commissioner said, well, I'm not even entirely sure how I'm going to interpret my mandate. So hang on a second, right? Sit tight. In the interim, he files an interim report in January of this year, which no one has seen. He continues to do work. As the July deadline for the final report approaches, we suddenly get changes to the terms of reference. We suddenly get an extension in October. And it's not until 14 months after the inquiry has began that the commissioner finally issues his interpretation on his terms of reference and these rules of procedure. Of course, it's not, I don't think, a coincidence that behind that was a lawsuit, an application by EcoJustice, which essentially sought to prevent the inquiry from proceeding until these rules of procedure were published, right? So essentially forced at the 11th hour, the commissioner finally released his rules of procedure, which are in of themselves hugely problematic in lots of different ways. Probably the most startling one is this unfettered right that the commissioner reserves onto himself to carve up the public record, to release parts of information but not others, which again, from a participant perspective, is just really difficult. So yeah, absolutely unprecedented in terms of these things.
Uh, in that vein, Martin, this is a very odd public inquiry. I'm fond of saying it's the least public inquiry we've ever seen, because there have been no public hearings. The environmental groups in question say that they have not been contacted. It's not clear where the commissioner was getting his information from. Isn't that odd?
Yeah, I mean, absolutely, right? I mean, these are, you know, I've described this whole inquiry myself as essentially Kafkaesque. I mean, it's, you know, it's quite something for even for an interim report to be released to the government, but never released publicly. And then after that, to have the terms of reference changed in a fairly significant way, right? At the time, the terms of reference were, you know, that the targets were only those groups that engaged in false and misleading information. And then to suddenly pull that back and say, well, as you know, opposition, which may have included disseminating false and misleading information. So suddenly now, you know, they might have been entirely justified. And of course, I've been on this, we've had the interviews before where, of course, I've showed that actually in the last 10, 15 years, there are numerous independent panel reports that substantiate concerns about the regulatory capacity of both the Alberta and federal governments in regulating the oil sands. We have reports about leaching into groundwater and the Athabasca. We have climate change issues. So it absolutely seems that in this most recent ruling, the commissioner seems to want to avoid dealing with any of the issues where the evidence may not support essentially the premier's, you know, broad talking points. And I think the reason for that, of course, is that unlike the premier, who can say, as politicians are generally able to do, you know, essentially say whatever they want, the commissioner is bound by rules of procedural fairness and administrative law generally, and that makes it more difficult for him to make those kinds of claims if he can't support them.
Well, we're all looking forward to this report, which we hope will be released next month, but who knows?
Well, so and no, I should add that in this most recent ruling on interpretation, he's also asked for he's indicated that he'll seek another extension. So the report was supposed to be due at the end of next month. He's now indicated that he will need more time. He received an extra $1 million in the summer. He's not asking for more money yet, but he's indicated that may be necessary. And he's also clarified that he doesn't intend ever to hold public hearings, as you described, but rather this would be done essentially as a write-in process, that groups might be an opportunity to write in their submissions, but that there would be no public hearing.
Well, I called this a witch hunt when it was announced a year and a half ago, and nothing has happened to change my mind. But Martin, thank you very much for this. Really appreciate it. I have no doubt we're going to be back talking about this odd public inquiry in the near future.
I suspect you're right.